The HOA president fined me $50,000 and tried to foreclose on my home, so I used a 100-year-old law to dissolve their $5 million association. There is a specific kind of tyranny that exists only in the American suburbs. It's not the government, it's the homeowners association. They're petty, they're powerful, and if you sign the wrong piece of paper, they can legally steal your house. I learned this the hard way when I moved into Oak Creek Estates, a wealthy gated community in Northern California. I thought I was buying privacy and security. What I actually bought was a ticket to a war against a woman named Patricia, the HOA board president, who wielded the community rulebook like a loaded weapon. I'm a software architect. I work from home. I bought the house, a sprawling mid-century modern on 2 acres, for $1.8 million. I put 40% down, I had significant equity. I specifically chose this lot because it was at the very edge of the development, bordering a protected forest reserve. I wanted peace. For the first 6 months, everything was fine. Then I decided to install solar panels. I'm an environmentalist, and with the massive roof space, I calculated I could go completely off-grid. I submitted the architectural plans to the Architectural Control Committee of the HOA. 2 days later, Patricia knocked on my door. She was a woman in her late 60s, wearing a Chanel suit that cost more than my first car. She didn't say hello, she handed me a rejection letter. "Solar panels are unsightly, OP," she sniffed the air. "They ruin the aesthetic harmony of the neighborhood. Denied." I politely pointed out that under California's Solar Rights Act, HOAs cannot unreasonably restrict solar installations. She smiled, a cold, thin expression. "Read your CC&Rs, OP. We have a historic preservation clause. We can restrict anything we want. If you install them, I will fine you." I installed them anyway. I knew the state law superseded the HOA rules. I thought that was the end of it. It was just the beginning. A week after the installation, I received a certified letter. It was a notice of violation. Fine, $500 per day until the panels were removed. I wrote a letter back, citing the state statute. Patricia didn't reply. Instead, the next week, I got another fine, this time for unapproved landscaping. Apparently, my native drought-resistant grass was weeds in her eyes. Fine, $200 per day. Then came the fine for commercial vehicle parking because my plumber's van was in my driveway for 2 hours fixing a leak. Fine, $100. In 1 month, I racked up $25,000 in fines. I went to the monthly HOA board meeting to appeal. The room was packed with terrified neighbors. Patricia sat at the head of the table like a queen. When it was my turn to speak, she cut off my microphone after 2 minutes. "The fines stand," she declared. "Pay them, or we will escalate." "I'm not paying for illegal fines," I said, standing my ground. "You are violating state law." "Then we will put a lien on your property," she said, not even looking at me. "Next agenda item." I walked out furious. I thought they were bluffing. An HOA is just a neighborhood club, right? They can't actually take my house. I was wrong. 3 months later, the balance of fines had reached $50,000. I received a legal document served by a process server. It wasn't just a bill. It was a notice of default and intent to foreclose. Under the laws of my state, an HOA can foreclose on a home to collect unpaid assessments. Patricia wasn't suing me in small claims court. She was utilizing a non-judicial foreclosure process. This meant they didn't even need a judge to sign off on it initially. They could sell my $1.8 million house on the courthouse steps to pay off a fake $50,000 debt, and I would lose my equity. I panicked. I called a real estate lawyer, a guy named Marcus, who specialized in HOA disputes. Marcus looked at the file and grimaced. "They are aggressive, OP. They've done this before. I see 3 other foreclosures in this neighborhood in the last 5 years. Patricia runs this place like a cartel. She uses the foreclosure threats to force people to pay, or she sells the homes to her investor friends for pennies on the dollar." "Can we stop it?" I asked. "We can file for an injunction," Marcus said. We can fight the solar panel issue in court, but it will cost you $50,000 in legal fees just to get started, and it will take 2 years. Meanwhile, the fines keep accumulating. If you lose, they get your house, and you owe my fees. I went home feeling defeated. I had the money to pay the fines, but it was the principal. It was extortion. If I paid her now, she would own me. She would find something else next month. I sat on my back porch, looking at the forest reserve behind my house. I loved this land. I didn't want to leave. I pulled out the thick stack of documents I had received when I bought the house, the title report and the original subdivision map. I started reading. I wasn't looking for a loophole in the solar law anymore. I was looking for the nuclear option. I wanted to know where Patricia got her power. An HOA draws its power from the master deed or the declaration of covenants, recorded when the neighborhood is built. This document acts like the constitution of the neighborhood. It runs with the land. I traced the history of Oak Creek Estates. It was built in 1995, but the land itself had a longer history. Before it was a subdivision, it was a single, massive ranch owned by a wealthy family in the 1920s. I kept digging. I went to the county archives, the dusty basement where they keep the physical books from before digitization. I pulled the records for the original land grant. And there, buried in a handwritten deed from 1924, I found something. The original owner of the ranch had sold a portion of the land to the county for a future water reservoir that was never built, but he had placed a restrictive covenant on the deed, a specific clause that stated, "No commercial or administrative entity shall ever be formed to govern or tax the inhabitants of this land, as it is intended for free agricultural use." It was a covenant against HOAs, written 50 years before HOAs were even invented. But here was the kicker. When the developer bought the land in 1995 to build Oak Creek Estates, they had filed a motion to remove this old restriction. They claimed they had notified all interested parties. But I looked at the notification list. They had notified the county, they had notified the neighbors, but they had failed to notify one crucial entity, the local land trust, which had inherited the rights to enforce the conservation of the forest reserve bordering my property. Because they failed to notify the land trust, the removal of the 1924 restriction was potentially legally invalid. If the 1924 restriction was still valid, then the master deed that created the HOA in 1995 was illegal from the moment it was signed. It meant the HOA didn't exist. It meant Patricia wasn't a president. She was just a crazy lady in a nice suit demanding money she had no right to collect. I felt a shiver run down my spine. This wasn't just a defense against a $50,000 fine. This was a weapon that could wipe out the entire organization. But I needed proof. I needed to be 100% sure before I pulled the trigger. And I needed to lure Patricia into a trap where she would admit, on record, that she was enforcing rules that violated the original deed. I called Marcus. "Don't file the injunction yet," I said. "I have a better idea. Let's invite Patricia to a mediation. I want to look her in the eye when I destroy her empire."
In high-stakes litigation, a mediation session is usually a place where two parties meet in the middle to compromise. But for me, this wasn't a negotiation. It was an interrogation disguised as a surrender. I needed Patricia to admit, on the record, that the HOA had knowingly bypassed the legal requirements when they formed the association. The mediation was held at the office of a neutral third-party arbitrator in downtown San Francisco. The room smelled of lemon polish and expensive cologne. Patricia arrived 20 minutes late, flanked by the HOA's corporate counsel, a slick lawyer named Mr. Sterling. No relation to the others, it just seems to be a popular name for sharks. Patricia looked at me with pure disdain. She sat down, smoothed her skirt, and didn't even look at the agenda. "Let's make this quick," Patricia said. We are here to accept your payment plan for the $50,000 in fines and your signature on a consent decree to remove the solar panels. If you don't have the check, we are leaving, and the foreclosure auction proceeds next Tuesday. My lawyer, Marcus, played his part perfectly. He acted nervous. He shuffled his papers. Miss Patricia, my client is overwhelmed. We are looking for a path to compliance. But before we agree to the payment, we just need to clarify the authority of the board regarding the solar restrictions. We want to make sure everything is by the book so OP doesn't get fined again. Patricia laughed. The authority comes from the master deed of 1995. It's absolute. We have the power to regulate all aesthetic aspects of the community. It's ironclad. I spoke up for the first time. I kept my voice low, submissive. But, Patricia, I found some old documents about the land, specifically a deed from 1924, regarding the agricultural use of the property. It mentioned a restriction against administrative bodies. Did the HOA board consider that when they wrote the rules? Patricia rolled her eyes. She looked at her lawyer, then back at me. That ancient history? We dealt with that decades ago. When the developers built Oak Creek, we filed a motion to expunge all prior restrictions. We wiped the slate clean. That 1924 paper is worthless dust. Are you sure? I asked, feigning ignorance. Because the law says you have to notify all beneficiaries of the restriction before you can remove it. Did you notify everyone? We notified the homeowners. That's all that matters, Patricia snapped. What about the land trust, the one that manages the forest reserve next door? They were listed as beneficiaries in the 1924 deed. Did you send a certified notice in 1995? Patricia's lawyer stiffened. He sensed the trap. He leaned over to whisper in her ear, probably telling her to shut up. But Patricia was too arrogant. She was the president. She didn't take orders. She gave them. She waved her lawyer away. The land trust? She scoffed. Those tree-hugging hippies? Why would we notify them? They don't live in the community. They have no say in how we run our neighborhood. We intentionally excluded them because they would have blocked the development. We did what was necessary to build this community, and no court has ever challenged us. There it was, the confession. She admitted to intentional non-disclosure. She admitted they knew the land trust had an interest in, and they deliberately excluded them to ensure the development went through. In real estate law, this is called fraud on the court. If you lie to a judge to get a restriction removed, the removal is void. Marcus looked at me. I gave a tiny nod. The trap was sprung. So, Marcus said, his voice suddenly dropping the nervous act and becoming razor sharp. Just to be clear, for the record, you admit that the HOA board was aware of the land trust's interest in the 1924 restriction, and you made a conscious decision not to notify them during the 1995 expungement hearings because you feared they would object? We did what was best for the homeowners, Patricia yelled, slamming her hand on the table. I am the president. I make the rules. And right now the rule is you owe me $50,000. Are you paying or not? I stood up. I wasn't the submissive homeowner anymore. No, Patricia, I said. I'm not paying because you are not the president. You are just a trespasser. I pulled a document from my briefcase. It wasn't a check. It was a draft complaint for declaratory relief and a motion to dissolve. Because you failed to notify the land trust, I explained, enjoying the look of confusion on her face. The 1995 removal of the restriction was illegal. That means the 1924 restriction banning any administrative body is still in effect. That means your master deed is void. Your HOA doesn't legally exist.
You have no authority to fine me. You have no authority to foreclose on me. In fact, for the last 20 years, you have been illegally collecting dues and fines from 200 families. That's millions of dollars in unjust enrichment and theft by deception. Patricia's face went from red to pale white. Her lawyer grabbed the document from my hand. He scanned it, his eyes widening as he read the citations of the 1924 deed and the lack of notification proof. This is ridiculous, he stammered, but his hands were shaking. The statute of limitations does not apply to a void deed. A deed obtained by fraud is void ab initio. There is no time limit on fraud. We are leaving, the lawyer said, grabbing his briefcase. The mediation is over. It certainly is, I said. But Patricia, one more thing. Since you tried to foreclose on my home based on a void authority, I'm also suing you personally for slander of title. That carries punitive damages. I'm going to take your house, Patricia, and I'm going to take your Chanel suits too. Patricia looked like she was going to be sick. They fled the office. But I wasn't done. I had scared them, but I hadn't stopped them. I knew Patricia. She would try to accelerate the foreclosure auction before a judge could rule on my new evidence. She would try to sell my house to a third party to complicate the title. I needed to freeze everything. And I needed allies. I couldn't fight this war alone. I needed the land trust. If I could get the land trust to join me in my lawsuit, claiming their rights were violated, the case would go from a neighborhood dispute to a major land use battle. I drove straight from the mediation to the headquarters of the Redwood Conservancy Land Trust. It was a small office, smelling of pine and old paper. I met with their legal director, a guy named Ethan. Ethan was skeptical at first. Why would a land trust care about an HOA dispute? Then I showed him the map. I showed him how the HOA had been encroaching on the forest buffer zone, cutting down protected trees to expand the golf course, using the authority of the illegal 1995 deed. If you join me, I told Ethan, we don't just dissolve the HOA, we restore the 1924 restriction. That means the golf course goes away, the forest comes back, and you get permanent oversight of the land. Ethan's eyes lit up. This was the holy grail for a conservationist. I can't authorize a lawsuit today, Ethan said, but I can give you a cease and desist letter asserting our claim to the restriction. That should be enough to get your temporary restraining order. Armed with the land trust support and the transcript of Patricia's confession from the mediation, Marcus and I filed for an emergency injunction the next morning. We weren't just asking to stop the foreclosure on my house. We were asking the judge to freeze the assets of the entire HOA, all $5 million in their reserve accounts, pending a determination of their legal existence. We dropped the nuclear bomb on the courthouse steps. Patricia thought she was fighting a guy with solar panels. She didn't realize she was fighting history itself. But as we waited for the court hearing, things got ugly. Patricia didn't just sit back, she weaponized the neighborhood. She sent out an emergency email to all 200 residents, claiming that a rogue homeowner, me, is trying to bankrupt the community and destroy your property values. She posted my photo at the gatehouse. She encouraged neighbors to express their displeasure. I woke up the next morning to find garbage dumped on my lawn. My car tires were slashed. Someone had spray-painted "traitor" on my driveway. I called Marcus. I said, "They're attacking me." "Good," Marcus replied. "Document everything. Every act of vandalism, every threat. Patricia is inciting harassment. It just adds to the damages. She is digging her own grave, OP. Just hold the line." I installed security cameras. I bought a shotgun. I wasn't leaving my house. I was going to watch the HOA burn, even if I had to sit in the ashes.
Warfare in the suburbs isn't fought with tanks. It's fought with inconvenience. Patricia knew she couldn't legally evict me yet, so she tried to make my life unlivable. 2 days before our emergency court hearing, I drove up to the main gate of Oak Creek Estates. I swiped my keycard. The light turned red. Access denied. I tried the keypad code. Invalid. I pressed the intercom button. The security guard, a guy I had waved to for 6 months, refused to look at me. "Sorry, sir," he said through the speaker. "Board orders. Your access privileges have been revoked due to safety concerns. You'll have to park outside the gate and walk to your property." My house was 2 miles from the gate. "This is an illegal lockout," I shouted. "I have a deeded easement. Open the gate." "Take it up with Patricia," he said, and clicked off. I didn't walk. I blocked the entrance with my truck. I sat there, honking my horn, creating a backup of angry neighbors in Mercedes and BMWs. When the police arrived, Patricia was there, smiling triumphantly, holding a copy of the HOA bylaws. "She is trespassing," she told the officer. "He has been banned from common areas." The police officer looked at the bylaws, then at my deed. "Ma'am," he said, "you can ban him from the pool, but you cannot ban him from his own driveway. That is constructive eviction. If you don't open this gate, I will arrest you for obstructing traffic and unlawful imprisonment." Patricia's smile vanished. She opened the gate. I drove through, but I saw the look in her eyes. She wasn't done. She was just getting started. The next morning, we were in Superior Court. The courtroom was tense. Patricia had brought the entire HOA board for moral support. They sat on one side, glaring at me. On my side, it was just me, Marcus, and Ethan from the Land Trust. The judge was a stern man who clearly hated HOA cases. He looked over the motion for the preliminary injunction. "Let me get this straight," the judge said, peering over his glasses. "You are asking me to freeze the assets of a $5 million corporation and halt a foreclosure because of a handwritten note from 1924? "Not just a note, Your Honor," Marcus said. "A valid, recorded, restrictive covenant that runs with the land. A covenant that was fraudulently concealed from the court in 1995. Marcus submitted the transcript of the mediation. He read Patricia's confession aloud. "We intentionally excluded them because they would have blocked the development." The judge's demeanor changed instantly. He looked at the HOA's lawyer. "Counsel, did your client admit to fraud on the court during a mediation session?" The lawyer stood up, sweating. "Your Honor, statements made in mediation are privileged." "Not when they admit to a past crime or ongoing fraud," the judge snapped. "If the formation of this HOA was predicated on a lie, then every contract it has ever signed is suspect." The judge banged his gavel. "Injunction granted. The foreclosure against the plaintiff is stayed immediately. Furthermore, given the allegations of financial mismanagement and fraud, I am appointing a court-ordered receiver to take temporary control of the HOA's finances. All bank accounts are frozen. No funds are to be dispensed without my signature." It was a victory, but it triggered chaos. Freezing the accounts meant the HOA couldn't pay its bills. The landscaping crews stopped coming. The pool turned green. The garbage piling up in the common areas wasn't collected. And most importantly, the security guards at the gate, the ones Patricia used as her private army, walked off the job because their checks bounced. The gates were left wide open. The wealthy residents of Oak Creek Estates were furious. They didn't care about my solar panels or 1924 deeds. They cared that their property values were dropping and their trash wasn't being picked up. Patricia tried to spin the narrative. She sent out another email blast, blaming me. "Due to the frivolous lawsuit filed by the rogue homeowner, our funds have been frozen. He is holding our community hostage." My neighbors started looking at me with hatred. I was the pariah. I needed to flip the script. I needed to show them that I wasn't the villain, I was the whistleblower. I knew that with the court receiver in charge, the financial books were finally open. I asked Marcus to request a forensic audit of the HOA's spending over the last 5 years.
The receiver released the preliminary report a week later. It was explosive. The report showed that while the HOA collected $2 million a year in dues, only $1 million was spent on actual maintenance. Where did the other $1 million go? Consulting fees. The report listed payments of $500,000 a year to a company called Viridian Management. I looked up the corporate registration for Viridian. The owner, Patricia's husband. And another $300,000 a year went to legal retainers. For a law firm that didn't exist, the checks were being cashed at a check-cashing store in Nevada. Patricia wasn't protecting the neighborhood aesthetics. She was running a kickback scheme. She was fining residents to distract them while she siphoned off the reserve funds. I printed 200 copies of the forensic audit summary. I highlighted the payments to Patricia's husband. I waited until Saturday morning. I didn't email them. I walked door to door. I put a copy in every single mailbox in Oak Creek Estates. I attached a simple note. I'm not the reason the guards left. This is. Your dues are paying for her husband's boat. The reaction was instantaneous. The neighborhood Facebook group, which had been a forum for hating me, suddenly turned on Patricia. People were posting pictures of the audit. They were doing their own math. By Sunday afternoon, there was a crowd gathering on Patricia's lawn. It wasn't a mob with pitchforks. It was worse. It was a mob of wealthy lawyers, doctors, and investors who realized they had been defrauded. They demanded a special emergency meeting to vote for the removal of the board. Patricia refused to call the meeting. She barricaded herself in her house. She claimed the bylaws required a 30-day notice. She was trying to buy time to shred documents. But I had the 1924 deed, and I had the land trust. Ethan, the lawyer from the land trust, called me. OP, he said, since the judge ruled that the 1924 restriction might be valid, technically, the HOA has no authority to stop a gathering. You can host the meeting on your property. It borders the forest reserve. We'll grant you a temporary permit for a public assembly. I sent out the invite. Town hall meeting, The Truth About Oak Creek, tonight at my house, 7 p.m. I expected maybe 20 people. 150 people showed up. They parked their Teslas on my unapproved grass. They stood on my patio under my unsightly solar panels. I stood on a chair. I didn't look like a crazy troublemaker anymore. I looked like a leader. Patricia told you I was the enemy, I said to the crowd. She told you I wanted to destroy the neighborhood. But look at the numbers. I fought her because she tried to steal my house, but she has been stealing from all of you for years. Every time she raised the dues, every time she levied a special assessment for road repairs that never happened, that money went into her pocket. A woman in the front row spoke up. She fined me $2,000 for having the wrong shade of beige curtains. A man shouted, she sued me for parking my boat in my own driveway. The stories poured out. Patricia had terrorized everyone. I was just the first one to fight back. We had a choice, I continued. We can let the court dissolve the HOA slowly, which will take years and drain our property values, or we can end it tonight. We can sign a petition to join the land trust lawsuit as co-plaintiffs. We can assert that the HOA was formed illegally. If we do that, the judge will have no choice but to dissolve the corporation immediately. But what about the roads? What about the security? We form a voluntary community services district. No fines, no architectural control, just a simple fund for roads and security managed by a third-party accountant, not a resident dictator. The crowd cheered. We passed around the petition. By the end of the night, I had signatures representing 80% of the homeowners. We had the votes. We had the evidence of embezzlement. We had the moral high ground. But Patricia had one last card to play. As the meeting was breaking up, blue and red lights flashed at the bottom of my driveway. It wasn't the local police. It was the sheriff's tactical unit. They weren't there for me. A deputy walked up the driveway holding a megaphone. Please disperse. This is an unlawful assembly. Patricia had called in a favor. She had told the sheriff that there was a riot at my house and that I was holding hostages. She was trying to get me swatted. But she forgot one thing. The court-ordered receiver was at the meeting. He was standing right next to me, drinking a beer. He was an officer of the court. The receiver walked down the driveway to meet the sheriff. He showed his badge. He explained the situation. The sheriff lowered his weapon. He listened to the radio dispatch. Then he turned his squad car around and drove towards Patricia's house. "What's happening?" a neighbor asked. "I think," I said, watching the police lights reflect off my solar panels, "that Patricia just filed a false police report. And in this state, making a false report of a violent emergency is a felony." The uprising was over.
The morning after the failed SWAT raid, the atmosphere in Oak Creek Estates shifted from anger to open rebellion. But while the neighbors were busy picketing Patricia's lawn, Marcus and I were busy destroying her financial safety net. We started with the insurance company. Every HOA carries a specific type of insurance called Directors and Officers Liability Insurance, or D&O. This policy protects board members from lawsuits. It pays for their lawyers and covers any damages if they get sued for making bad decisions. It's the reason people like Patricia feel invincible. They think they're spending the insurance company's money, not their own. But D&O policies have one fatal exclusion, the Fraud and Criminal Acts exclusion. Marcus sent a package to the HOA's insurance carrier. It contained the transcript of Patricia's confession about the illegal 1995 deed, the forensic audit showing the embezzlement to her husband's company, and the police report regarding her filing a false emergency call against me. 3 days later, the insurance carrier sent a letter that dropped like a guillotine. They issued a reservation of rights, followed immediately by a denial of coverage. The letter stated, "Due to the overwhelming evidence of intentional fraud, criminal embezzlement, and malicious acts outside the scope of board duties, the carrier is denying all defense and indemnity obligations." This meant Patricia and the other board members were no longer protected by the $5 million policy. They were now personally liable. They would have to pay for their own expensive defense lawyers, and if they lost, they would have to pay the damages out of their own bank accounts. We didn't just sue the HOA as an entity anymore. We amended our complaint to sue Patricia and the 4 other board members individually. We went after their personal assets. We filed motions to attach liens to their homes in Oak Creek Estates. The effect was immediate. The other 4 board members, let's call them the yes men, panicked. They were wealthy doctors and retirees who had let Patricia run the show because they were lazy. Now, facing the loss of their own net worth because of her crimes, their loyalty evaporated. They called an emergency executive session, excluding Patricia. They voted 4-0 to remove her as president immediately. But it was too little, too late. "You can't just fire her," I told the board members during a tense meeting in my living room. "You enabled her. You signed the checks to Viridian Management. You are complicit in the embezzlement. Unless you want to lose your houses to me in court, you need to give us everything." The yes men broke. They handed over the private email servers they had been using to bypass the official HOA records. These emails were the final piece of the puzzle. They detailed exactly how the kickback scheme worked. Patricia would mandate unnecessary beautification projects, repaving roads that were fine, replacing perfectly good streetlights. She would force the board to award the contracts to Viridian Management without competitive bidding. Viridian would then subcontract the work to cheap, unlicensed laborers for pennies on the dollar, and Patricia's husband would pocket the massive difference. In one email, Patricia wrote to her husband, "The reserves are at $3 million. We need to approve the new clubhouse roof project before the end of the fiscal year so we can transfer another $400K. Don't worry about the permit. I control the ACC." We had the smoking gun. This wasn't just mismanagement. It was grand larceny and conspiracy. Armed with the insurance denial and the internal emails, we moved for summary judgment on the civil claims. But first, we had to depose Patricia. The deposition took place in a small, windowless conference room. Patricia looked like a ghost of her former self. She wasn't wearing Chanel. She was wearing a tracksuit. Her husband sat next to her, looking terrified. They had been forced to hire a criminal defense attorney because the civil deposition could be used against them in a future criminal trial. Marcus started the questioning. Ms. Patricia, did you authorize the transfer of $450,000 to Viridian Management on October 12th? Patricia's criminal lawyer leaned over and whispered. Patricia looked at the camera and said, "On the advice of counsel, I invoke my Fifth Amendment right against self-incrimination." Did you know that Viridian Management was owned by your husband? Marcus asked. I invoke the Fifth, she repeated. Did you file a false police report claiming OP was holding hostages? I invoke the Fifth. In a criminal trial, pleading the Fifth cannot be used against you, but in a civil trial, the jury is allowed to draw an adverse inference. Basically, if you refuse to answer, the jury can assume the answer is yes. By pleading the Fifth to every question, Patricia essentially handed us a total victory in the civil suit. She admitted guilt by silence. The judge didn't wait for a jury. Based on the adverse inference and the mountain of documentary evidence, he granted summary judgment in our favor. The damages were calculated. Restitution of embezzled funds, $2.5 million. Punitive damages for fraud, $1 million. Slander of title for trying to foreclose on me, $500,000. Legal fees, $250,000. The total judgment against Patricia and her husband was $4.25 million. They didn't have $4.25 million in liquid cash. They had spent it on boats, vacations, and cars. So we moved to the collection phase. We executed a writ of execution. I watched from my front porch as the sheriff's deputies arrived at Patricia's house, the biggest mansion in the neighborhood. They weren't there to arrest her yet. They were there to seize assets. They towed her husband's boat out of the driveway. They loaded her Mercedes onto a flatbed truck. They went inside and cataloged her furniture, her jewelry, and yes, her Chanel suits. Everything was seized to pay the judgment. But the ultimate irony came next. Because Patricia couldn't pay the full judgment, I forced the sale of her home. I, the man she tried to evict, became the primary creditor on her property. The foreclosure auction was held on the courthouse steps, the same place she tried to sell my house, but this time it was her house on the block. The house was sold to a third-party investor for $2.25 million. The proceeds came to me to be distributed back to the HOA reserves and the victims. Patricia was evicted. She stood on the curb, watching the movers take the last of her boxes. She looked at me. There was no arrogance left, only shock. She had tried to use the HOA rules to destroy me, and instead, those rules had been turned into a noose around her financial neck. "You ruined my life," she whispered. "No, Patricia. You ruined your own life when you decided that rules were for other people. I just balanced the books." But this was just the civil victory. The files we uncovered, the embezzlement, the kickbacks, the tax evasion on the stolen funds, were too big to keep private. The court-ordered receiver had a legal obligation to report criminal activity. He sent the whole file to the district attorney's Major Crimes Division and the IRS. While Patricia was moving into a rental apartment, the IRS was building a case for tax evasion. She hadn't declared the $2.5 million in kickbacks as income, and the DA was looking at 20 counts of embezzlement. We had stripped her of her power, her money, and her home. Now the government was coming for her freedom. But there was one final piece of business: the HOA itself. The judge had ruled that the HOA was formed illegally in 1995 because of the hidden 1924 deed.
But dissolving a corporation that owns roads, sewers, and common areas is complicated. We needed a final vote. We held the vote in the community park. It wasn't just a vote to dissolve, it was a celebration. All in favor of dissolving the Oak Creek Estates Homeowners Association and transferring all common assets to the Voluntary Community Service District, I asked. 200 hands went up, not a single dissent. We signed the papers right there on a picnic table. With the stroke of a pen, the HOA ceased to exist. The restrictive covenants were wiped clean. The architectural committee was disbanded. People were cheering. Someone popped a bottle of champagne. For the first time in 20 years, the residents really owned their homes. They could paint their doors red. They could plant vegetables. They could install solar panels. Ethan from the Land Trust shook my hand. You did it, OP. You freed the land. We did it. Now, let's go plant some trees. The war was over, but as I walked back to my house, passing the spot where the gate used to be, now permanently locked open, I realized something. I had a taste for this. I had spent a year learning real estate law, forensic accounting, and corporate strategy. I had taken down a tyrant, and I looked at my inbox. People from other neighborhoods were emailing me. They had heard the story. They had abusive HOAs. They had corrupt boards. They needed help. Dear OP, one email read, my HOA president is fining me for having a wheelchair ramp. I smiled. I wasn't just a software architect anymore. I was an HOA hunter. Patricia is currently awaiting trial for grand larceny and tax evasion. She faces 10 to 15 years in prison. But the story doesn't end here. I've taken on a new case, a massive HOA in Florida that is foreclosing on active duty soldiers while they are deployed overseas. Next week, I'm flying to Miami to meet with a JAG lawyer. If you want to see me take down a corrupt association that preys on veterans, subscribe and turn on notifications. You won't believe what we found in their ledgers.